Hi, my name is Steve Parr and I'm a Vancouver business lawyer, and today we're going to talk about what happens if you die without a will. So there are three things that I'm going to cover off in this video, and before I get started, this is only applicable to residents of BC because in BC we're governed by the Wills, Estates and Succession Act, and that's provincial legislation. So let's get into it. So first thing to know about dying without a will is that the distribution of your estate is of course going to be very unclear. The default rules of the Wills, Estates and Succession Act are going to apply, and so I'm going to cover off some of the common scenarios here. So scenario number one, if you have no spouse, your estate is going to be divided amongst your descendants, and if you don't have any descendants, it's going to go to your parents, and then to your parents' descendants. If none of those apply, then to your grandparents and to your grandparents' descendants. And it gets more complex from there. Scenario number two, if you have a spouse but no kids, then your estate is going to pass to your spouse. Scenario number three, if you have a spouse and children with that spouse, then the first $300,000 of your estate is going to go to your spouse, and then half of the remainder of your estate will pass to your spouse, the other half will go to your children. Fourth scenario, if you have a spouse and kids but from a previous relationship, a different relationship, then $150,000 is going to go to your spouse, and then half of the remainder of your estate will go to your spouse as well, and then the other half will go to your descendants. The second thing that you need to know about dying without a will is that it can be very messy for your next of kin. It can be very messy for your family that you're leaving behind. So they will need to go through a certain process to apply to the court and to provide notice to everybody else who also might be eligible to fulfill that role of an administrator. So it can be a complex process, and if there's any kind of disagreement or dispute over who should be in the role of distributing your estate, then that can introduce a lot of mess, delay, and can be a costly thing. And something else that you want to keep in mind here is that the role of an administrator is a demanding one. It's a significant and it's an important responsibility, and if you have passed in an unexpected way, then the person who is filling that role, they may not be emotionally or mentally prepared to deal with it, so it can be a very difficult thing for somebody who's to deal with when they're already dealing with a lot of grief. So it's far better to have somebody set up and prepared and have already accepted that role in advance of your passing. And the third thing to know about dying without a will is that it introduces more uncertainty, it can create more confusion, and it can create more dispute within the family that you're leaving behind. So as I mentioned above, the role of the administrator could be contested, and who is a beneficiary of the estate, that could also be contested as well. So in general, the process for winding up an estate after an administrator has applied to the court and received a grant of administration, it can take over 2 years. And that process is much shorter if there's a valid will in place with clear instructions. And finally, if there are minor children involved, it's absolutely essential that a will be put in place. A will is where you would designate who is going to be a guardian and a backup guardian or an alternate guardian for your children in the event that you pass. And those persons would work with the trustee or the executor that's named in your will to provide for your children. Without that in place, a guardian is going to need to step forward and apply to the court to obtain the legal right to become the guardian of your children, and any monies that are designated towards your children are going to go to the public guardian and trustee, so your guardian will have to apply to the public guardian and trustee to receive those funds and provide for your children while they remain minors, which takes time and can be a frustrating experience. So in sum, everybody should have a will, even if you have no assets, spouse or kids. If you have no assets, spouse or kids, it's going to make it a lot simpler for your next of kin, for your family. And if you do have a spouse, kids, or assets, then it's absolutely imperative that you have a will. So thank you for watching, and if you have any questions about wills or estate planning, feel free to leave a question below or contact me directly.